well Dr. Akhtar Parvez, University Librarian, Maulana Azad National Urdu University, Hyderabad, and all the participants, a very good morning to you all. I, Professor Preeti Mahajan, on behalf of the Department of Library Information Science, Panjab University, Chandigarh, and on my own behalf, welcome you all in the new series of the webinars entitled PU DLIS Webinar Series. As you are aware that the Department of Library Information Science has hosted 21 webinars in the month of April to June 2020 in a webinar series on the theme Information Generation, Dissemination and Use during COVID-19 lockdown. The webinar series were highly appreciated by all our participants as well as the speakers, as it resulted in productive academic activity and enhanced the professional knowledge of our attendees. Keeping the same spirit in mind, we at the Department of Library Information Science are starting the new series today and hope it go a long way as a professional learning process for the LIS students, research scholars, and the professional colleagues. Now, I take this opportunity to introduce the speaker of the webinar today. We have amongst us Dr. Akhtar Parvez, who's a university librarian at Maulana Azad National Urdu University, Hyderabad. He has about 32 years of professional experience and has worked in prestigious institutions, including National Council of Applied Economic Research, New Delhi, the American Center, USIS, New Delhi, DELNET, India International Center, ICRA, and IIM Indore. He has authored and edited 10 books, contributed 20 papers in journals and books, and has delivered more than 200 invited lectures. He specializes in designing processes in various operational areas of library management and has successfully implemented them in his libraries, leading to staff efficiency enhancement. He is the managing editor of Journal of Library Management and is on the editorial board of International E-Journal of Library Science and International Research Journal of Library Information Science, published from Saudi Arabia. Dr. Parvez was recognized as an outstanding management librarian by Association of Indian Management Scholars and Institute of Rural Management and has received many awards, including Promising Professional Award, Best Young Librarian Award, Vishwa Lakshmi Best Management Librarian Award, etc. Dr. Parvez is the founder member of Management Libraries Network, that is ManLibNet, and has been contributing to ManLibNet activities since 1998-1999. Today, Dr. Parvez would be speaking on copyright and fair use. As we know that copyright infringement is an offense against the creator of the material, while fair use are the guidelines that help enable individuals to use that copyrighted material for academic and entertainment purposes. However, one must know as to where and how much copyrighted material can be used fairly as per law. May I now request Dr. Parvez to throw more light on the concept of fair use in terms of copyrighted material. Dr. Parvez, please.
Thank you, madam. Thank you very much. It's indeed a pleasure, to be here in this webinar. And I'm very happy and very grateful that you considered inviting me for this talk on this topic of copyright concerns and fair use. And let me just make this disclaimer that I'm not an expert. I'm a law background guy who can, tell you each and everything, but I know copyright to the extent which is important for me to perform my job as a librarian. So I think in that context, let me just begin my presentation. And before beginning my presentation, I would also like to thank the Panjab University for the invitation. So let me just share my screen. One second. Please bear with me. I'm just
No issues.
I am not able to present.
You are the presenter now.
But how do I, share my screen? I don't see
It's
any
it's
button.
the third icon. पहला mic का है, दूसरा video है. Third is the
Ah,
content.
I'm third one actually. It says open system preference. Just a second.
Sir, you can, I'm sorry, good morning, sir. You can select which application you want to do. You can select the whole screen.
I am.
All right. Thank you, sir.
Just a second, please. I think there is some fire issue here. Just a second. Now I think
Yes, it's okay.
Okay. Thank you. Okay, so as I said, I'll be speaking on copyright concerns and fair use, and it's important that we understand what fair use is, because generally people are not very sure what fair use is. Some people say you can make 5% photocopy of a book. Some people say you can make 10%. So there are various versions which comes when you talk of fair use. But I today would like to tell you a few tips by which you can really understand how to make fair use of a particular document. So this is my university. I'm not going to talk much on that. The only thing I would like to say is that ours is a university which has a lot of satellite campuses, and we impart education from primary to PhD. So that is one of the salient features of our university. So copyright is part of intellectual property. So intellectual property basically refers to, just a second please, refers to creation of mind. Anything which is created by your mind, that comes under intellect property or intellectual property. Like for example, you have inventions, then you have designs, you have researches, you have images, anything which is creation of mind. Like for example, the way I am talking to you is also a kind of intellectual property, and the ambit is quite wide. Anything, as I said, you do would probably fall under intellectual property. So patents, copyright, trademarks, trade secrets, geographical indicators, they are some of the things which come under copyright. And by these, by having a patent, copyright, etc., we get some financial benefit, and we also get a recognition in our field. And intellectual property, like any other law, is protected by a particular law. And the problem with copyright law is that it is a state created monopoly. And monopoly is not good, as you know. But this monopoly is actually given to protect the uh, rights of the person who creates something, or you can say the rights of the creator. So though it is a monopoly, but monopoly in a limited sense, and there's a balance between the interest of the inventor or creator and the interest of the general public. And in this is the United Nations Declaration of Human Rights, which actually included this particular protection in their declaration. And if you see this document under Article 27, it says everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. So it is so important that it has been included in the Universal Declaration of Human Rights. So let us understand what patent is. Patent is basically exclusive right granted for an invention, which is generally valid for 20 years or so. And then we have trademarks, and trademarks you all very well know, these are some of the symbols, these are basically trademarks which are also protected by intellectual property laws. Trade secret is something, like for example, how Coke is prepared, the formula. So that is basically trade secret. And there are a lot of other things which form part of trade secrets. So what is important about the trade secret is it is commercial valuable information. It gives a protection to the secrecy of that particular formula or whatever, or you can say, and which is not readily known to people, and it provides competitive advantage to a particular organization compared to other organizations which are in the same business. So now the question is why intellectual property laws are required. If, for example, intellectual property laws were not there, then probably, we would not have come out with so many inventions. We would probably not have come out with so many textbooks. Lot of apps every day come. And why these apps come? Because people want money out of it and people want recognition. So if these things were not protected, perhaps people were not motivated to invent so many things. And Google is one very important creation which has become daily life of all the people that we have. So these are some of the important IPR laws. So I will not go into the details. We will basically talk on Copyright Act of 1957 and various exceptions that this act has. So copyright laws grant authors, artists, performers, producers of music and other creators protection for their works. And this is given under Section 14 of the Copyright Act. So my suggestion to you all would be to once go through the Copyright Act so that you have better clarity of various provisions of Copyright Act. And as I said, it is a state-created monopoly, but limited in a sense. Why limited? Because this monopoly is for particular number of years, lifetime of the author and some number of years. And it basically is the monopoly is to incentivize the creators. If this monopoly or law is not there, probably creators will not be incentivized to create something which may be good for general public. And anyone who contributes protectable expression is protected under the law. So for example, as I said, see, today I am performing. So that is also a kind of a protectable expression, which is protected under the IPR. So right from, poetry, fiction, software, films, plays, dramas, paintings, photographs, designs, sculptures, everything, is covered under this law, or you can say is protected under the law. So let us briefly discuss the history of Copyright Act in the United Kingdom, which is believed to have been originated during Roman period. And in the middle of 15th century, the idea of copyright emerged in the United Kingdom, where a printer used to purchase a copy from the author and print that copy exclusively. So what does it mean? Exclusively, there are two kinds of rights a creator has. One is exclusive, another is non-exclusive. Say for example, I give exclusive right to a particular bookseller or publisher to distribute my books. So that right is given only to one person. But non-exclusive right is something, when say when I subscribe to databases, that those databases are actually available to large number of people. Okay, so that is non-exclusive right, where I have the right to distribute my right to various people. So that is non-exclusive. And that is the reason, as I said, that printer used to purchase a copy from the author and print it. So that is why it is called copyright. And there was a company of the government of England, that is called the Royal Company of Stationers, which had the exclusive right to publish. Nobody else could publish. If somebody else was publishing, it was basically a crime. And like delivery of books, the Royal Company of the Delivery of Books Act, which we have in India, the Royal Company of Stationers was also supposed to deposit a copy of every book which they were publishing to the Oxford University Library under an agreement, which was signed by the librarian of Oxford University Library called Thomas Bodley in 1610. And after that, the libraries of Oxford University have been named after him. So if you go to this website, you can see. And in India, the copyright was first introduced during the British period in 1847, and then in 1941 when the British Raj was there, and then the current one that we have is 1957 Copyright Act. These are some of the amendments. These are almost 6 amendments that we had from 1957 to date. And basically, these amendments were done to accommodate new things, like, for example, digital things, exceptions for, say, physically challenged people or especially able people. So, to accommodate various things, there were a lot of amendments. So now the question a lot of people ask is whether registering copyright mandatory or adding the symbol essential for protection under IPR laws. So, whether you add a symbol or not, see, if you have anything, as I said, protectable expression, it will be protected under the Copyright Act. But the only any advantage of putting this C, which you all see every day in different books, that it tells people that who owns the copyright. Say for example, uh, the C in our books is written just before the publisher name, so which means the publisher has the copyright. Sometimes it is before the author's name, so that means the copyright is with the author. So in case you want any kind of permission from those authors to extract something from their research, you can always contact them. So it is basically a contact point which tells you who owns the copyright. So simply by adding C is enough. You don't actually need to go and register it. And if you add this C, it will be respected not just in India, but all the countries which have which are part of Bern Convention. I will talk about that. And the Copyright Act 1957 stands for the legal rights exclusively given to authors, as I already said. So copyright protects works of authorship, whether it is published or unpublished, in any tangible medium of expression like writing, music, art, computer software, film, etc. But here you see, if you want protection, originality is very important. And as I just said, that copyright works in India enjoys same rights and privileges in other countries which are members of Bern Convention. And India joined this Bern Convention in 1928, and the United States joined this only in 1988. Earlier, United States had different number of years after the death of author. We'll talk about that. But when they joined this convention, they made that 60 years to 70 years. So we will talk about that. Similarly, foreign copyrighted works are protected in India also. So these are some of the conventions, and most important for, you can say for copyright purposes is Bern Convention of 1886. And then, after it was 1967 by World Intellectual Property Organization. So I was talking about copyright duration. So copyright is basically for a definite period. Okay, so that is why it is called limited monopoly. So definite period means, of course, throughout the lifetime of the author and a particular number of years. So if you say you take India, so it is lifetime of the author and 60 years, and these 60 years are calendar years. So for example, if one of the author passes away in say 2020, then calendar year or the calculation will start from 1st January 2021. And if there are 2 or 3 authors, then and the first author, say for example, passes away in 2011, then next is 2015, and then the third one passes away in 2020, then those 60 years actually will count from the passing away of third author, not from the first author. So that we have to remember. And this is given under Chapter 5 of Section 22 to 29 of the Copyright Act. And initially the copyright was for 14 years in the United States. Then it got extended to 28 years, and it kept extending. So today, sometimes the copyright exists for over 100 years. So lifetime of the author, and of course 60 or 70 years, whatever you can say. And the one reason, why the copyright is for so many years is that because, of course, life expectancy is also going up. So now the important question that we have to understand today is who owns the copyright. Okay, so that is very, very important that we must do. So whether the copyright owner is the author, or it is employer, publisher, or the government. So when author creates something, he says that he is the copyright owner, but then publisher says that you have transferred the copyright to me, so I am the owner. Okay, then employer says that, you see, you have published something during the course of your employment, so I own the copyright. Then the government says, no, the copyright is with us because it has such information which needs to be protected by the government. But irrespective of these things, librarian has to basically decide how he can or she can make fair use of the copyrighted work. So that is, there the librarian's role becomes extremely, extremely important. So just to give you a sense of ownership of copyright, for works in the course of employment under a contract, employer has the copyright. Okay. Say, for example, if I come out with a document, on the right hand side, you see, there is a document called Manu Code of Ethics in Research and Publications, and this was prepared by us, and we are members of this one of the committees. So I cannot say that the copyright is with me, because this document has been prepared for my university. So my university has copyright of this particular document. But if I write a book, if I write a journal article, then usually that is the employee or the author will have the copyright, unless and until there is an agreement which states otherwise. So that we have to very clearly understand. But there are some researches which are sponsored, okay, by different funding agencies. So in that case, the copyright will have different understanding. Either the funding agency will have, or the university have, or jointly, you see, all the stakeholders will have the copyright. It all depends, what your agreement says. And as I already said, in case of all government work, government is the owner of the copyright. And if there are, say, for example, there are 2 authors, then both the authors will have the copyright. Say, for example, I write a book and I ask one of my friends to make some tables for me, and I insert that. So he also basically becomes an author. So if I any point of time, if I get some revenue, so I will have to share that revenue with the second author, unless and until there is an agreement which states otherwise. So it is very, very important, whenever you create anything, you must put everything in black and white, so that we have complete clarity about the copyright ownership. So the creator's rights are as under: to reproduce the copyrighted works. So I can obviously reproduce the copyrighted works, whether in my class or wherever I want. To distribute copies of works to public, like I can sell it, I can give it on rent, I can transfer it. As I already said, I can transfer also. You see, the copyright is something which you can also have, and the person whom you transfer the copyright, he or she also has that license to use your material. So then, to produce or prepare derivative works of the copyright material. So what are derivative works? Derivative works are those works like, for example, second edition of book, third edition, translation. So if I want to convert my fiction into play or movie, I can do that. So these are some of the examples of derivative works. And then I have the right to perform the copyrighted works like dance, music, performance, etc. I can display the copyrighted works as an owner of the copyright, and I can also grant permission or licenses. And as I said, you see, the licenses or permissions can be exclusive also and non-exclusive also. So copyright, as I told you initially also, is applicable to both published and unpublished works. So there is generally some kind of confusion between plagiarism and copyright. So I have tried to give some major points which actually differentiate the copyright infringement and plagiarism. Say, for example, copyright infringement is using someone else's work without obtaining their permission, whereas plagiarism means that someone claims attribution for a work which he or she did not create. So, for example, I steal something from some author's book or article and I say it is my work. So that is plagiarism. But copyright is something when I use something without permission. So that is copyright infringement. Then in case of copyright, the affected party can lodge a complaint, whereas anybody in case of plagiarism can go to the higher education institution and complain about the cases of plagiarism. Copyright infringement cases are taken up by the court of law, whereas plagiarism cases are handled by the Departmental Academic Integrity Panel and Institutional Academic Integrity Panel as per the UGC regulation of 2018. And there can be some other bodies also, in private institutions or some other academic institutions where the mechanism may be different. Now, copyright comes under criminal law, okay, where the person can be even convicted and imprisoned. Where in case of plagiarism, in extreme cases of repeated plagiarism, in level 3, employee can also be terminated. So I think that these are some of the major differences between copyright infringement and plagiarism. Now, the more complex is the copyright in the digital environment. Why? Because it is easy to get digital document or digital content or digital information. So how do I decide about using a copyrighted material? So for example, if I'm writing a book and if I want to use someone else's material, so how do I decide? What are the issues that I have to keep in mind? So I think let us understand this in detail so that we have complete clarity. So for that, first of all, we'll have to have a clear understanding of the term public domain, exceptions, licensing, permissions, and fair use. So public domain, I mean, you all know, but we'll talk about that. Exceptions basically are which are allowed, for example, in a class or somewhere else, at a religious place, etc. So let us understand these things one by one. So public domain refers to creative works that are not protected under copyright and any other form of IPR laws. This does not mean that whatever is available on the internet is in public domain. So even documents which are in public domain may have some copyright. So we should not take things from internet as it is. We have to have clear understanding whether it is a copyrighted material or not. So how things fall under public domain. The either the copyright term has expired, so as I said, lifetime of the author and 60 years in India, or the copyright owner puts his or her work in public domain. So, and by saying that, I'm putting it in public domain, but once you put your creation in public domain, you cannot just tomorrow decide that, okay, I will not put it in public domain, it's a copyrighted material. Or the work is not copyrighted. So, for example, titles of books, facts, ideas, slogans, or short phrases, these cannot be copyrighted. So, these are major three things which fall under public domain. A lot of people use images, okay, in our PPTs or somewhere, but we never realize that even those images have copyright. So what we should do is, if you go to Google, and if you go to tools here, so here you see there are a lot of things which says how do you want to filter it, labeled for reuse with modification, labeled for reuse, labeled for non-commercial reuse, labeled. I mean, these are some of the things. So you have to select appropriate filter from here and accordingly use that image. So you should not just use any image which is there on Google. And there is another website called Flickr. Here also, if you see, it says all Creative Commons. So all Creative Commons licenses images you will find there. So what are Creative Commons license? I mean, there are various licenses where you can use copyrighted material by simply saying or attributing that you have used that. There are common creative licenses which even allow you to mix, or you can say change the original work and come out with a new kind of product. Similarly, if you go to YouTube, you will see that there are a lot of videos, but all videos may not be copyright free. So how do you decide that these are the copyright free or Creative Commons videos? Say, for example, here you see my video on physical stock verification of library books, and this is under Creative Commons licenses. And if you go to filter here on the YouTube, you see there's one filter called Creative Commons. So if you choose this, you will get only those videos which are licensed under Creative Commons. So that I think we have to understand properly. Similarly, for music, I generally see that a lot of people use music in their videos. And when you run those videos, it keeps saying that there is some copyright issue with the video. So it is better that we take only those music which are actually usable, right? So I suggest that you go to this creativecommons.org licenses, where you see different kinds of licenses. So I'll not talk much about this today. So after public domain, let us understand what are exceptions. What is the meaning of exception? So in a physical classroom, there's a lot of things which you can use. You can use someone else's work for teaching, provided that organization is not for profit organization, and you should know that the work should have been lawfully made, or say, in other words, the copyright copies or recording or videos which you are showing in your class are not pirated copies. And it is important that we tell a student that these are copyrighted material and they should not distribute it. So I think there is a very clear clear distinction between using in the classroom and distributing it. So if you are using it in a classroom, that is perfectly fine. But if I start distributing that particular copyrighted material outside my class, so that may be copyright infringement. So this we have to understand very clearly. And even if you are recording your classroom proceedings, make sure that you have students' permission, so that tomorrow you don't have any problem. Then in online classes, as I said, it is very difficult to make sure that we obey all copyright rules. Here the institutions, wherever these online classes are happening, must make sure that there is a proper mechanism to protect the copyright of the creator. And the difference between online classes and the physical classes is that in physical classes you can use large amount of copyright material, whereas in this you have to have restricted usage. Say for example, in a class I can distribute an article, okay, for students to read, but I cannot put that complete article in a video or in an online class, okay. So I suggest that only maybe link can be provided, so that you are not accused of infringing the copyright. And wherever required, you must credit the source. And students, as I said, must be told that all these things are subject to copyright and they should not distribute it. And not just a student, but staff should ensure that they do not interfere in the technology that is used for protecting the copyrighted material. Some of these suggestions, maybe whenever you are using online classes, material, copyrighted material in online classes, try to lock files, and instead of putting everything on the YouTube, you can do live streaming. You can disable right click and use a low resolution picture so that nobody is able to download and use it. So I think some of the material which you subscribe in your libraries, cannot just be used like that in the online classroom. You will have to go to the licensing agreement which the librarian has signed between with the publisher. So accordingly, you have to use that material. And then there are exceptions for library, and those exceptions are available only to public libraries. But this does not mean that public libraries in the sense that we librarians understand. Public library, in my view, is any library which is not for profit library. Any even our academic libraries of our universities, which are of course not for profit. And maximum, you can make 3 copies of any book if they have been damaged. But you have to make sure that these copies are not available at a fair price in the market. And then you see, you can store each and every document. When I say store, means you can scan and store it in a library, each and every document that you have in the library. But the copyright says you can only store, okay, you cannot just distribute. So that under that clarity you have to have. So for reference purpose, you can always keep it in the library. And even if you want to make it accessible to students, make sure that you do not make such things accessible to students outside the library premises. Because if you do it, probably it will mean distribution, which is again copyright infringement. So the purpose of copying any chapter from books should be preservation, not distribution. That understanding we have to have. And if you are making photocopies, we should ensure that we just have cost to cost. It should not be a profit making venture when you start photocopying. And in a library, there is no problem, putting some notice that all library books, material, etc. is copyrighted, and we have to do copyright compliance. And there are a lot of exceptions for especially abled or physically challenged people. Like for example, if you want to convert a book into say text into a recording, you can do that. There are various softwares, but that you can do only for use of by specially abled persons or students. Then comes the licensing, which is very, very important. And licensing for librarians, you all see how licensing is given to you by the publishers. So you have to, when you sign licenses, you have to make sure that whether this licensing is for use on your IP, or you can have remote access also. And in the digital content, there are a lot of restrictions when you compare it with print material. So print material, you can give anyone like book, but if it is an ebook, perhaps it will have a DRM issue, that is digital rights management, and you will not be able to give it so freely. So there are a lot of things which comes under this licensing. As I said, DRM and no DRM. If you have to purchase ebook, my suggestion to you that you purchase those books which are no DRM, or you can say which are copyright free. so that your students can easily download it and use it. And whenever you sign an agreement, make sure, see, if you purchase some database, so wherever possible, you should see that you purchase those database for lifetime or unlimited number of years. And if you don't have that option with the publisher, then make sure that, so if you discontinue tomorrow, you should have the option of having one copy of that product that you have already, for which you have already paid. Can you make course packs from the subscriptions? I mean, that also you have to negotiate with the publisher. Now, sometimes what happens, we generally see that a lot of journals get discontinued by the publisher. So what happens, are those titles going to Clocks? Clocks is basically a non-profit organization where all the journals titles which get discontinued become part of Clocks, and that Clocks has the repository. And then, as I said, the distribution of digital content comes with severe restriction, unlike the print material. So these are some of the things which you have to understand about licensing. Then, permissions. The third or fourth important thing to understand in copyright is permissions. So you have to identify who owns the copyright, and then send a formal request if you want to use that copyrighted material. And the email will be sufficient because of the Information Technology Act of 2000. And whenever you are sending any request for permission to any of the creator, make sure that you have complete clarity of what kind of permission you want. Say, for example, if you want to use a video, okay, so or the cover of the video, you want that particular portion of the video just in the beginning of your video, or towards the end, or towards the middle. And similarly, the photograph. So if you want permission to use a photograph, that photograph you want to use in the book or on the cover, because there's a possibility that if you are using it on the cover, the price may be more, okay, compared to when you use it in the inside the book. And sometimes copyright holder is not identifiable, so you have to send emails and emails, and you may not receive any response, and they are actually not obliged to respond. So it is up to them whether they want to respond or not. So this permission part is very important. And then the most important thing that we want to discuss today is the fair use. So fair use basically is a legal doctrine which allows a person to make limited use of copyright work without the permission of the owner. So that is important. And here what it says, you can use only the limited work, not everything. So some of the examples I like are reproduction in the course of fair dealing, reproduction for educational purposes, like say for example, if some student comes to me, if he wants a photocopy of a chapter of a book, there's no problem. And there are countries which say, as I said in the beginning, that 5% can be used, some say 10%. So there are various kind of definitions. There is an agency called Indian Reprographic Rights Organization which says, you can make 15% of any book photocopied. But I really don't understand why people go to this Indian Reprographic Rights Organization membership, because whether you have this membership or not, you can even then you can make some fair use. So it may be 15%, it may be 10%, it may be 20%. So it all depends on the kind of material that you used. So unfortunately, the copyright protection is recognized by all the countries, but the clarity on fair use among all these countries which have signed Berne conventions, they do not have clarity of this fair use, and I find it quite complex. So now we have clarity of what is public domain, what are exceptions, what is licensing, what are permissions, and what is fair use. So I come back to the same question: how do I decide about using any copyrighted material? So I, I always advise that, you see, these are few things which we must see. So first thing what we should see is that is the work copyrighted or not. So if it is not copyrighted, if it is in public domain, I can use it. If it is not in public domain, is there any exception which we just discussed, like classroom exceptions, exceptions for physically able people? So is there any exception which I can use? And if there are no exception, then what does the agreement or the license says? And if that is also not, if I don't find that helpful, maybe see I can consider having a fair use. And then if I feel that okay, fair is also not possible, then again I think of getting permissions. And even if I fail in all these 1, 2, 3, 4, 5, then I can once again explore the possibility of fair use of the copyrighted material. But the question is, how do we actually decide what is fair use? So that is the crux of the whole matter. So I got a very interesting document on one website of Columbia University, where they have defined this into 4 parameters. One is what is the purpose of use of copyrighted material, what is the nature of material that is being used, and what is the amount of use. So how much amount, whether I'm using a very little amount of that copyrighted material or more, and the effect of use. So there is this particular gentleman called Kenneth D. Cruz. He has given this chart. So one is of course purpose. So this first column is for favoring fair use, and second is for opposing fair use. So if the purpose is teaching, research, scholarship, there is no problem. You can make fair use. Then you have to see that it should be not for profit organization. So as long as you're writing a criticism, you are writing a comment, you are writing a news report, there is no problem. And this is transformative or productive use. So what is this transformative or productive use? So that is very, very important that we must understand. Say for example, let me just give you some uh, uh, transformative use. Say if uh, I have a book, and and somebody else want to write another book on similar ideas, okay? But that person has to show something new. It should not happen that you are simply repeating the same uh, idea what you have. And then the next one is the restricted access. So if, as long as the use of copyrighted material is restricted, there is no problem, that will come under copyright. And the last is parody. So what is parody? I mean, you see a lot of songs, and in Akhtar, there is a small video that says "so sorry." So there are songs and new songs are made, so that parody is also permitted in uh, fair use. And then if you see the opposing fair use, so if it is commercial activity, then there's a problem. If you are making some profit, then there's a problem. If it is for entertainment, then again it is a problem. If it is bad faith behavior, if you are denying credit to the original author, so these will go against the fair use of that particular copyrighted material. So this is the purpose. Okay. Now, what is the nature of material being used? So if it is published work, perfectly fine, there is no problem. But if it is unpublished, then probably you may need to have permissions from the copyright holder. As long as the information that you are you want to use as fair use is factual or non-fiction, that is perfectly fine. But if it's something is highly creative, then you have to think 100 times, or maybe you need permissions. And if it favors educational objectives, it is perfectly fine. But if it is a fiction which you want to probably use, I think then there's a problem. Then comes the amount of use. So a small quantity is fine compared to large quantity. Portion use is not central or significant. So that is very important. You may use a small portion, but that portion should not be central or so significant that it infringes the copyright. And then amount is appropriate for favored education purposes. So this is the fourth thing, that is the amount of use. And the last score is of effect of use. So if the user owns lawfully acquired or purchased copy of original work, there's no problem. But if it affects or replaces the copyrighted work, then there is a problem. So these are some of the things that we have to analyze before using any copyrighted work. And so I hope with this scorecard which I just show, I'm sure some clarity it would have brought in your mind. Now, I'll just take few 2-3 minutes to discuss about this. This DU photocopy case, which you all know, I'm not going to repeat this. Here, unfortunately, the justice and law even ignored the quantity. If you remember, I just said that you see, if the quantity is small, that is perfectly fine. But here, justice and law even ignored the quantity. So that was something very strange. And there was an Indian Express editorial which was very critical of this judgment, which says that ruling in DU copyright case reflects the inability of Indian courts to integrate legal outcomes with robust business models. So I think this is a very, very critical editorial by Indian Express. If you get time, please read it. So as I said, the judgment even ignored the quantity. One can always photocopy books and distribute, citing the Delhi High Court judgment. But in my view, though this judgment has not been challenged anywhere, this is applicable. But academic institution should interpret the judgment in the right spirit and should not consider the court judgment as a license to violate the prevalent copyright and intellectual property norms. And being the same fraternity we are in, I think we must respect copyright of its creators. Then this is Hathi Trust website. They actually went. Some publisher went to the court against these people, saying that you have infringed the copyright. But Hathi Trust said that we are only using the transformative works. So what transformative works was that? The creation of a full text searchable databases was a transformative use. The copying was not excessive, and the full text search function did not serve as a substitute for the books that were being searched. So the transformative work should not be a substitute. That we have to understand. So here also, so far the High Court judgment was in favor of Hathi Trust, but it is still pending in the Supreme Court. So there is one more thing, which recently happened. Some publisher went against Internet Archive, so you can go on the internet and see. And I would say that we have to understand fair use quite well. We must, as librarians, read the fine prints of licensing agreement. You just don't sign that. Read each and everything, whether it is for library subscription or you are giving rights to publisher for publishing your article. So if you are giving rights to publisher, all the rights, then obviously you will not be able to do a lot of things which you want of your own creation. So it is better that when you sign license agreement, please negotiate with the publishers. And because permissions last for more than even 100 years, so whenever you take permissions, keep those permissions safe, so that in case of any dispute, you are able to show those things in the court of law. And as I said, we must respect IPR, and to the extent possible, we should publish in open access platform, and we must promote the common creative cause by adding more and more content in that. So I think with this, I finish my presentation, and I think I took a little more time, so I'm sorry for that, madam. So if there are any questions, I'll be very happy to take up those questions.
Thank you very much, Dr. Parvez, for your highly
Preeti ma'am, are you connected?
I'm so sorry. I'm so sorry. Thank you, Dr. Parvez, for your highly informative inputs regarding the copyright issues and its fair use, especially the tips given by you in case of libraries, where libraries purchase e-books, which you said should be DRM free. You must be aware of the archival rights and knowledge of transformative use, which is very, very important from librarians' point of view. Now, with these words, may I request Neha to take up the questions, please?
Yes, ma'am. Good afternoon, sir. Sir, I'll be taking up questions with you. I hope I'm audible to you.
Yes, yes.
Sir, I'll start with a couple of questions. Most of them are done by Professor Lakshman Rao. Firstly, I'd like to thank him for joining us. And now I'll be taking up his questions. He is a retired professor from DLIS Osmania University, Hyderabad. First question that I would like to ask is, if a book is purchased, can we digitize the same for external use as an internal use in the library?
Yes, the copyright 2012 amendment allows us to make electronic copies of each and every material that we have in the library. Okay, but the amendment does not say that you can distribute. So it says you can only store. So when it is supposed to store, so it cannot be considered in a very narrow term. So you can also make it accessible to students within the four walls of the library premises. I would say not on the university. So there is no problem, and the 2012 Copyright Amendment provides streaming in an electronic form.
All right, thank you, sir. Now, you have stated about 3 copies can be made when out of print book is there. Can be 2 even if the book is not purchased by the library or the individual?
Your got broken. Can you come again?
Yes, sir. I'll repeat it. That you stated that 3 copies can be made when the book is out of print.
Yeah.
Can the same be also be done if it is not purchased by the library or individual? That is, if the person has purchased it, can the same is the same applicable even then if the book is out of print?
Yes or no, both. Because yes, if you have tried your level best to get it from publishers, from booksellers, from various libraries, you can even go to a library for interlibrary loan instead of making a copy. But if you think that is a highly used book and which can be used for research and training, I don't find any problem in that. But before that, you must exhaust all the options of purchasing that book.
All right. The next question is, please tell about copyright on religious and spiritual documents published. The thought content is known to everyone and not real contribution of any author is there.
No, you are saying, so basically this is copyright orphan. Okay, so nobody has copyright.
Okay.
Is that so? Is that so? I mean,
okay, the question that he's asking is, please tell about the copyright on religious and spiritual documents published.
no, as long as you are reading something, there is exception which is the Copyright Act. Say anything, you can go to a mosque or temple or a church and read it. There's no copyright issue. But when it comes to using something from that religious, so as long as I feel it's fair, no. So I think that concept, the understanding of the concept fair use is very, very important. So you should be able to justify that. You see, it was a fair use, and the score which I just showed, one was purpose, then the amount of use, etc. All those things coming want to make fair use of a particular document.
All right. Thank you, sir. Then there is another user, Vikash. He has taken up a question. IP right under union list or concurrent list?
Your voice got broken again.
I'll repeat. IP right is under union list or concurrent list in India?
I don't know. I'll have to check.
All right. The last question that I'm taking up is any copyright for the videos to be sent through social media?
Of course, yes. Of course, yes. See, you just cannot put everything on social media, whatever is there in the on the internet. So, as I said, you see, you have to have you must filter those with Creative Commons licenses. And Creative Commons licenses also, you must ensure that which Creative Commons licenses it has. Accordingly, you should make use of that. So my suggestion to him would be that he should go to Creative Commons website and go through all the licenses, what the permission it gives for use of those videos. But you should not put any video. That I also accidentally put liked a song very much, so I put it on my social page, and I was getting warning again and again. This is a copyrighted material. So finally, I removed that.
Many of them have given a feedback of informative session and it was very useful knowledge. But one of them is also given in the chat box a message that about the pandemic period, can the librarian send the link of a storybook, fiction or non-fiction, to the students in this situation?
There is no problem sending the link, but that link is where? Is it on the publisher side? Is it on libraries? Let's say, for example, if you have uh, scanned a book, okay, in the library. So, do you want to send that to him, or how do you? If it is publisher page and you have the license to use, no problem. But if you don't have license, then there's a problem. And even if you have to scan something in your library, in view of well, I think there is no problem as long as you are not distributing a large number. I'll just give an example. I see on WhatsApp groups that every day we see a lot of PDFs. Okay, some people say send these PDFs of magazines like Outlook, etc. I think that is not the right thing. And why it is not the right thing? Because you're not supposed to distribute it. I'll tell you, one of the person who was forwarding such magazines PDF was, it's the magazine says that you can share these stories. Sharing the story is different from sharing the whole PDF. Okay, sharing a story with a particular person is perfectly fine. If you share it with a large number of group, that will come under distribution. So that distribution has to be avoided. Hope I could clarify.
Yes, it's clear now. Sir, now with this, I would now request Professor Deepak Chakrabarty to give a vote of thanks. These are all the questions that needed to be taken up. Thank you.
Thank you, Neha. Am I audible?
Yes, sir. Yes, sir.
Okay. On behalf of the department, Panjab University, and the participants, offer my sincere thanks to Dr. Akhtar Parvez, University Librarian, Maulana Azad, National Urdu University, Hyderabad, for delivering such an insightful talk on copyright and fair use, and sensitizing us on a topic which has always gathered doubts and queries, owing to its vastness and application to the whole universe of knowledge. Your talk was highly informative and beneficial for the participants, including practicing librarians and LIS educators alike. We appreciate your making time in your busy schedule to enlighten us today on a very important topic. I again thank Dr. Parvez for enriching our knowledge through your comprehensive presentation. Thank you again for your time.
Thank you, sir. Thank you. Thank you, Panjab University. Thank you, madam. Thank you.
Thank you, Dr. Parvez, and thank you all the dear participants. We'll be meeting again tomorrow with a new speaker at the same time, 11 a.m. Fine. Thank you. Take care.
Bye-bye.
Bye. Thank you, everyone.